Hello there. I'm Jorge Contreras at the University of Utah, and I thank you very much for the invitation to join you today. I'm very sorry not to be able to join you in person, but I hope these comments are helpful to you and that they contribute to the discussion at this very important event. I'll be talking today about gene patenting, and in particular, the case Association for Molecular Pathology versus Myriad Genetics that I describe in my book, The Genome Defense: Inside the Epic Legal Battle to Determine Who Owns Your DNA. So the book and the case are relatively well known in the patent world. The case was an important case that was decided by the US Supreme Court in 2013, which had a major impact on patent law in the United States with follow-on implications around the world. But more than just a patent law case, this case had interesting implications for important areas such as access to health, scientific innovation, the way that government intervenes in litigation to make policy, the commoditization of the individual, and our ability to know about ourselves through our genes. So, a little bit of doctrinal background to get us started. To get a patent in the United States and in most countries, there are a number of statutory requirements. The first of these requirements is that the thing that you are going to patent, the invention, must be patentable subject matter. In most countries, there are 4 general categories of subject matter that can be patented: apparatuses or machines, processes and methods, articles of manufacture, which are things that are made by machines, and finally, compositions of matter. And this is the category that I'll be focusing on primarily in this talk. Composition of matter patents are quite broad and powerful. They allow you to patent a new form of matter. Typically today, that would be a new metallic alloy or a plastic polymer, a type of carbon graphite. And if you invent a new material and get a patent on it, then you control all uses of that material. So for a new form of plastic, for example, you would control all rights to make that plastic into drinking bottles or wall insulation, clothing, carpet, or any other device or material. The patent on the composition gets you all of that, so it's quite broad. Now, one exception to this doctrine that has been handed down by the courts in the United States for well over a century is that you cannot patent things that are simply found in nature. So a new material, whether it's a fungus or a type of moss or a bacterium that you discover in the forest for the first time, even if you are the first one to discover it, if it is naturally occurring and can be found out in the world, you cannot obtain a patent on it. That also applies to natural substances that you simply purify or isolate from their natural environment. To distinguish what can be patentable from products of nature, we talk about articles or substances that are man-made or that are markedly different in some way from the naturally occurring product. So one example used by the Supreme Court in the Myriad case involves a baseball bat. A branch of a tree that falls to the ground is a natural product, cannot be patented. But if somebody takes that tree branch and carves it very carefully and deliberately into a baseball bat, well, then that bat can be patented if the bat is novel and inventive and meets the other criteria for patentability. This test has been around in the patent system for hundreds of years. In the US, it was most recently articulated in the 1980 case Diamond versus Chakrabarty, which involved the ability of a researcher to patent a bacterium that he had genetically modified in order to make it more attracted to petrocarbons or oil spills. This is a bacterium that would help to break down those spills in order to make the bacteria more attracted to oil, 4 plasmids were inserted into the bacterial DNA. This bacterium existed in nature, but once it was modified in this way to a form that did not previously exist in nature, it became patentable. Now, the natural extension, you might think, to patenting a bacterium is patenting a human gene. Genes, of course, are found in the nuclei of all of our cells. They each exist along a long strand of DNA called a chromosome. We each have 23 pairs of chromosomes in our genomes. And again, all of these reside in the nuclei of our cells in our bodies. When these are in our bodies, in our cells, they, of course, are not patentable because they are products of nature. But what happens if you isolate one gene from the chromosome? Each chromosome in the human body has, 1 or 2,000 genes on it. These genes are scattered along the chromosome. In between them are a lot of other nucleotides of less known function. The genes themselves, though, exist only on the chromosome in the human body and do not exist in freestanding form in nature. Therefore, the theory goes, if one were to isolate a gene from the chromosome, take it out of the cell, and multiply it, amplify it in the laboratory so that you now have a petri dish full of one particular gene, this is something that does not exist in the human body in nature and therefore should be patentable. And in the late 1980s and the early 1990s, researchers started to do this, and the US Patent and Trademark Office agreed with this theory and allowed patents to be obtained on those isolated and purified human genes. And as you can see from this table, from the 1980s through the early 2000s, a lot of human genes were isolated and sequenced, and as a result, they were patented, most of them closely associated with particular human diseases or conditions, such that by 2005, 2 researchers at MIT estimated that approximately 20% of the human genes that were known were patented in some way. And these, of course, included the BRCA1 and 2 genes discovered at University of Utah, which I'll talk about in more detail next. So Myriad Genetics was a Utah-based company, a company that spun out of the University of Utah, that was the first company to patent these BRCA genes that were closely associated with breast and ovarian cancer. They did this after a heated scientific race with a dozen other research groups around the world. But unlike academic research groups, Myriad was a company. It was formed precisely for the purpose of finding these BRCA genes. It had backing from venture capitalists. It had an alliance with the Eli Lilly Corporation. And for all of these reasons, Myriad was the first entity to isolate, sequence, and then patent the BRCA1 and 2 genes. Now, this was done, of course, in accordance with existing law at the time. Nevertheless, a number of ethical complaints were raised against Myriad from its first introduction of a BRCA test in the mid to late 1990s through about the mid-2000s. And these complaints largely revolved around Myriad's pricing for its genetic diagnostics test. Because Myriad owned the patents that covered the BRCA genes as compositions of matter, it could control all testing that involved those genes in the United States. So no one else could perform a genetic diagnostic test using the BRCA genes. Well, what did that mean? That meant that Myriad could charge whatever it wished to for this test, and it arrived at a price of a little over $3,000 for its basic test. This was a high price for a diagnostic test, especially a test for healthy patients who did not have a disease yet. Note that if a patient had one of the particular mutations in the BRCA genes that Myriad's test could detect, that patient would have up to an 8 to 10 times greater chance of obtaining or coming down with breast or ovarian cancer than a general member of the population. This boils down to something for a young woman of about an 80% lifetime risk of one of these potentially fatal diseases. So this expensive test was viewed as ethically problematic to many, since the test, if it identified one of these mutations, would enable a patient to get prophylactic surgery, the removal of the breast tissue or the fallopian tubes and uterus, to prevent that development of cancer down the road. Another problem that was pointed out relating to Myriad's monopoly on this testing was that it prevented patients from getting confirmatory testing from another laboratory. So the prophylactic surgery that I mentioned, if you received a positive test result from Myriad, is of course very serious and life-changing surgery, such that in most cases, when facing a surgery like this, a patient would wish to receive a confirmatory test or a second opinion from another healthcare provider. That wasn't possible in the United States, since Myriad was the only vendor who was permitted to perform this testing. Another issue with the patent monopoly in cases like this is that the monopoly really removes the incentive for the holder of the patents to improve its product. It has a monopoly for 20 years or 17 years in this case, meaning that there's really no incentive to make the test better because there are no competitors to perform this testing. And as a result of this, Myriad did not include additional mutations in its tests that were being discovered in the laboratory, to the very severe detriment of some patients who had those mutations and had otherwise clean Myriad tests, not knowing that the test didn't cover all of the deleterious mutations in these genes. Similarly, as I mentioned, researchers in the laboratory were allowed to use the BRCA genes for academic research, even though the genes were patented. But if those researchers detected a deleterious mutation in a patient who participated in a research study, the researchers could not tell the patient that they had one of these deleterious mutations. The patient instead would have to go to Myriad if they wished to get that information. As a result of this, research in general was found to be chilled on genetic tests, and as the science advanced, it was found that there were impediments to multi-gene testing as more and more diseases and health conditions were linked not to single genes, but to multiple genes. So all of these complaints were raised against Myriad, notwithstanding the fact that none of these really related to the core issue of the patents that Myriad had acquired on the BRCA genes, only the effects of those patents. So this situation, again, the patents were started to issue in about 1996, 1997, and immediately gave rise to the issues that I mentioned. This issue was well known to people in the genetics policy arena, but not to many others. The American Civil Liberties Union is a century-old civil rights, civil liberties litigation organization in the United States. This gentleman, Chris Hansen, was a senior litigator at the ACLU during this time period. Had never heard of patents on human genes until a young science advisor at the ACLU named Tanya Simoncelli approached him and made him aware that this was happening. And even though he didn't believe her at first, he finally was convinced. And when he realized what was happening, that companies could and were patenting entire human genes, he was rather outraged and exclaimed, "Who can we sue?" and started a 4-year-long process by which the ACLU studied this issue and started to prepare a lawsuit to challenge the patenting of human genes. The ACLU, unlike a lobbying organization or other activist groups, achieves policy change through litigation. That is, not through administrative or regulatory or legislative rulemaking, but by lawsuits decided by judges or juries. And this is a very interesting way to achieve policy change. But to do it, you need a number of things, including plaintiffs who are injured, defendants who committed injuries, actual injuries, and then some litigation that can be achieved in some remedy that can be achieved in litigation. So the ACLU, in mounting the case against Myriad and gene patenting, identified 20 groups and individuals to serve as plaintiffs in this lawsuit. These plaintiffs included genetic counselors, geneticists, physicians, advocacy organizations, scientific organizations, and most importantly, 6 individual women who had been unable to obtain BRCA testing from Myriad because of its pricing or their inability to meet the eligibility criteria for Myriad's testing. So the case was brought in 2009 by the ACLU, first in New York at a trial court, then at the Intermediate Appeals Court in Washington, D.C. But the ultimate destination of this case was the U.S. Supreme Court. And the ACLU generated significant interest in this case, in this issue, among advocates and activists, such that it was very clear as it was going up to the Supreme Court that there was significant public interest in it. This all culminated in the surprising announcement in 2013 by actress Angelina Jolie, who revealed in a New York Times op-ed that she herself suffered from a positive mutation in her BRCA genes that made it very likely that she would contract breast or ovarian cancer, and as a result underwent a prophylactic double mastectomy earlier that year. This op-ed received a lot of recognition around the world, including by the members of the Supreme Court who were deliberating on this case. And so the result of the litigation was the Supreme Court's ruling in 2013 that DNA sequences found in the human body in their natural form were not patentable, that they were subject to this product of nature rule, with an exception that if a laboratory created a genomic sequence, a DNA sequence that just included the coding regions of that DNA and not all of the other stuff in between, it might be patentable. The caveat to this is that Myriad and genetic diagnostic testing companies did not do that. Nevertheless, this is an important exception to the rule. But the case and the decision had an immediate impact. The price of diagnostic testing for BRCA mutations dropped by half almost immediately. And because the Supreme Court ruled in this case, all other patents on all other genes in the United States also automatically became unenforceable. So the extent stretched far beyond breast cancer and the BRCA genes. And there was a significant long-term impact of this decision. The baseline human genome, of course, has been in the public domain since the Human Genome Project finished its work in the early 2000s. But even though that is the case, and new human genes are not being discovered or patented, new health-related variants of human genes are being discovered all the time. And this was well illustrated during the COVID-19 pandemic, in which human genome sequences related to long COVID susceptibility, COVID resistance, and so forth were being discovered on a regular basis. There's also another very important impact that the Myriad case had, and that's on non-human genomic sequences. So if you think back to the earlier disease outbreaks of SARS, MERS, and H5N1 influenza, all of those viral genomes were patented very soon after they were discovered. This caused various delays in research, reluctance in collaboration, research bottlenecks, and disputes. None of that happened with the sequence of the SARS-CoV-2 virus that caused COVID-19. Researchers collaborated very rapidly. The sequence was put up on GenBank extremely soon. No patents were applied for, as far as we know, and none have been granted on the basic genomic sequence of this virus. Now, this all being said, the debate is not over. Even though the Myriad decision this year is 10 years old, it's been subject to continual criticism, and periodically bills have been introduced in the US Congress to try to reverse the decision. Most recently this year, 2023, Senators Coons and Tillis have introduced a potential legislation that would explicitly reverse the effect of the Myriad case, would again make human genes not as occurring in the body, but purified and isolated, they would be patentable once again. So this is a live issue, an issue that is still important to many people on both sides of the debate. So I hope that this talk has been helpful to you and has given you an appreciation of this case. You can find many more details in the book, The Genome Defense, or on my website, genomedefense.org, which includes a wealth of material about the case and about the issues that might be of interest. So I thank you again for your time and wish you the best in the conference to come. Thank you.